and welcome to a newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape.
Hi, Richard.
Hello, Lizzie. What have you been doing lately?
Not much, just a whole lot of recording stuff with you. So,
And it's swelteringly
and
hot.
nodding.
Swelteringly hot. Needs to
It
get
is
cool.
indeed. So we're going back in time to the 5th of August when we did a webinar on commercial lease updates, but in particular on the banning of upward-only rent reviews. And we were inundated with questions, as is expected, because it's a new topic. So we're going to run through some of the questions we didn't have time to do. So the first question we were asked, can you have the higher of either indexed or market rent?
I presume on the banning or the proposed ban of upwards-only rent reviews, and the government sprung it upon us all. The idea is if you've got a rent that can't be ascertained what the rent increase is going to be at the beginning, then it's got to be upward and downward rent review. So you can't have basically you could have the higher of an indexed or market rent, but if rents fall, then it's got to be downward based as well. I think if both of them fall.
Okay, next question. To clarify, does this mean that stepped rents will be allowed, but have to have a reason behind it, such as RPI?
No, stepped rents will be fine. Whether they come in, start to be used more frequent, we'll have to see. But stepped rents can be ascertained from day one, and so they're permitted by the legislation.
And the next question, also on stepped rents, is it clear that stepped rents will not be seen as an anti-avoidance mechanism? Do you think it is likely people will grant leases for a shorter period of time, such as 5 years, so they can uplift the rent?
Yeah, the legislation, the English Devolution bill, says that if the rent can be ascertained from the very beginning, then it won't be subject to upward and downward rent reviews. So it's not really an anti-avoidance. Whether they start to be used a lot more, stepped rents, we'll have to see, and time will tell. But the professed reason for the legislation was to sort of stop tenants in the high street going out of business, because they can't get the benefit of a downward rent review when more rents are falling. Most tenants in that kind of situation have probably got 5-year leases or less already, and they haven't got rent review clauses. And I think you're probably right, because if you've just got a fixed term of 5 years, 54 Act excluded, then you just offer them another 5-year lease at the end, and with whatever rent you think you can get away with. So I think it's going to just add to the shortening of lease durations, yeah.
How will it impact index-linked reviews with collars and caps, as they, in effect, provide a stepped rent?
Yeah, index linking will, again, because it's not ascertained at the very beginning, will be subject to upward and downward rent review. I've got to say one thing, it's not really answering the question, but I think index linking is probably a better bet, because over a 5-year sustained period, it's highly unlikely that things like CPI, as it's going to be much more so in the future, are going to actually fall. But governments separately have announced there's an ability to pass regulations through the Secretary of State in the actual provisions, Schedule 31 of the bill, and the governments separately say they're going to consult on rent collars, which I know you're an expert on, Lizzie. I
said I know what it was once, and now you're professing me to be an expert.
No, just contact Lizzie if you've got any questions about rent collars. They're going to look quite separately at potentially introducing legislation allowing rent collars, but they'll not consult on that until the legislation is up and running and enforced. So that's a long, long way down the line before we actually know what's going to happen with rent collars. One suggestion is they might allow rent collars if there's a corresponding rent cap, but index linking, will be basically subject to upward and downward review. Who knows what will happen with them in the future.
So someone asking more of a general question, what are they trying to do with this? Is it to address some potential imbalance in the power of parties, or is it something more technical?
I don't think there's any logic to it. You can't read too much into it. I say what they say is that in the explanatory pages and notes is that it's to stop people in the high street being not being able to get the benefit of downward rent reviews when the market's going downward. But as I mentioned, those kind of people probably don't have rent reviews anyway, with exceptions.
It doesn't sound like professionals in the market were consulted about the impact, or rather the lack of impact this would have on their targeted tenant base, this person is saying. Do we know if there was a consultation?
They don't seem to have consulted on it. It came completely out of nowhere. And I say on a bill which is primarily about English devolution. It's 339 pages long, the bill. And it's just crammed into the end of the clauses and the end of the schedule 31. And I have talked to people about this. I've talked to knowledge lawyers and firms and the likes about it. Because it's obviously well formed. It's been well thought out. It's not just been sort of written on, the piece of paper as they were about to introduce it into Parliament. So you do wonder where it's come from. There was a private members bill in 2022, but like all private members bills, or almost all of them, it came to nothing. But I did check the private members bill, and it doesn't bear any relation to what's in the Schedule 31. So I did make a Freedom of Information Act request. The government's got 28 days to respond yes or no. It's around about 28 days since I made the request, and I've not heard anything. So who knows? Rest assured, we shall put something in on websites and the likes if I did get anything. But it doesn't seem to have had any consultation whatsoever. And I think it's a lot political, I have to say. I mean, it's all well and good, those nasty landlords who the government doesn't seem to like, but it's also people's pensions is all this. As is the Leasehold and Freehold Reform Act, but that's for another day.
The next question, thoughts on where there are multiple leasehold interests and subleases in place. There will be a huge impact where existing longer term leases are upward only, such as long leaseholds, but the subleases are shorter and will be subject to upward and downward reviews.
I think it's probably a lot more fundamental than that. I mean, as was mentioned, the legislation is not retrospective. It's not intended to be when it comes into force. You're going to have a two-tier system for substantial time period with existing leases being upwards only. If there's a sublease, it's a bit more worrying than that because, again, post the legislation coming in, the subtenants will be the ones who almost certainly are an occupation for business purposes under a lease, and they're the ones who will come within the 54 Landlord and Tenant Act. By the act of subletting, the head tenant comes outside the 54 Landlord and Tenant Act, and so you can have a upward only rent review. There's nothing stopping you having upward and downward rent review, but you're going to have a sort of system whereby the subtenants in certain markets, the rent is reduced, and the head tenants, the rent stays the same, which is going to be a bit catastrophic.
Indeed. The next question, you said this is not a certain change. If it is to change, when can we expect it to take effect and when would it be announced?
The government was saying originally in their impact assessment 2027, 28. It may not happen. It may not happen in its current form. It's a long way down the line. It's just got first reading, which is just its introduction into the House of Commons. Second reading is due on September the 2nd. We're in mid-August at the moment. And who knows? It's going to take a year for it to pass through Parliament, and I suspect another year or two before anything actually happens. But yeah, that's what the government's saying in the impact assessment. They've got such a majority in the Commons. I suspect it will happen, if not in this current guise. There were proposals back in 2001 under the Blair government to introduce a ban on upwards only rent reviews, but that didn't get anywhere. This is its sort of resurrection in a much more concrete form.
And did you say it also affects contracted out leases?
Yeah. It applies whenever the lease comes within the definition of the Landlord and Tenant Act 54, Section 23, which is, you occupy under a lease at least partly for business purposes. And that includes contracted out leases. So contracting out is not going to be a way out of this. They are within the 54 Act. You've just served the notices to contract out.
And the next question, do you think this will see a move away from Landlord and Tenant Act renewal provisions? Given timescales to get cases into court for Landlord and Tenant Act determination, why would a landlord grant a lease within the Act?
Again, it applies to contracted out leases as long as they fit that definition in section 23. And the definition of a business is as wide enough to cover, as I mentioned, things like corporate bodies, which are things like churches, charities, non-profit making organisations. So it's not an option really. I mean, contracted out leases will come within the Act.
The next question about high street rental auctions, is there a central list of which councils have adopted the scheme?
The answer is not, so far as I know. There isn't, but there's I think there's 11 councils. Shall I tell you what they are if I can remember them, Lizzie?
If you can, go ahead.
The first three were Mansfield, Darlington and Bassetlaw. They were, let's say, last December. And Bournemouth, Christchurch and Poole have some sort of supervisory role, but I'm not quite sure what that's all about. If somebody from BCP can tell me. Then back in March of this year, there were several more, which is my memory serves me, a lot of London, Hillingdon, Westminster and Camden. Lichfield in Staffordshire, Northamptonshire, Broxtowe, which is Nottinghamshire, Barnsley and North Somerset as well. Weston-super-Mare. Whether just because they are what's called early adopters doesn't mean to say they are, designated areas. But how you can find out whether it's been designated as a high street rental area is it should show up on local land charges.
And also sticking with that, will there be reserve rents on the auction in place by the landlord, or will there be a market rent assessment?
It's just basically, who bids what at the auction, and there's not going to be a reserve. At the end of the auction process, the landlord will be told about all the bids. They've got 2 days to decide which tenant to have, which doesn't have to be the one with the higher rent. If they don't make that decision, the local authorities can choose either not to rent out, and having spent a large amount of time and money going through the process, or they must grant a lease, or through the landlord grant a lease to the highest bidder, and unless they think it's not reasonably practical, which they can't afford it, something like that. But it's not going to be a market rent, or it must be down to the auction process.
So what if the local authority can't get in touch with the landlord?
It doesn't deal with it specifically, but there are some regulations under the legislation, and the legislation itself says that how you contact the landlord is by either personal service, service recorded delivery, registered post, last known address. So if the landlord isn't getting in touch with them, it's just they've served the last known address. If the landlord's contacted them by email, service can be via email.
Is there any ability for landlords to refuse to do up the property to the relevant standard because they don't have sufficient funds?
Yeah, the tenants can claim a liquidated damages sum after a certain time period of £55 per day. And there's also the possibility of the tenants being able to do the work themselves and deduct it from rent, which will mean the landlords will have even less sufficient funds.
How does the 54 notice and stat dec work, as the local authority is not the landlord, if the landlord doesn't want to be involved?
It's a good one, that, because the local authority can exchange its contracts on behalf of the landlord, but it makes it clear that it's exchanging on behalf of the landlord. And then when the lease is actually finally granted, it's supposed to be the landlord doing it, and if the landlord refuses, the landlord does it on behalf of the landlord. But the warning notices have to be served before the contract, because you have to serve warning notices, and they've got to be contracted out before the tenant commits themselves, including an agreement for lease, which is a contract. And the local authorities would have to do so, I presume, as agents for the landlord, but I can't think anything in the legislation itself that specifically deals with it.
Okay. Is there any guidance on rent deposits when sourcing a tenant via the auction process?
Rent deposit will be either £1,000 or 3 months rent, whichever's the higher. And that's in the legislation.
Will surrender and regrant also apply to residential leases?
This is nothing about high street rental auctions or about upwards and downwards rent reviews, but it applies to leases across the board, surrender and regrant. I think I was specifically mentioning sort of things like an implied surrender when you add to the term and or add to the demise. It'll apply equally to residential, agricultural as well for that matter.
And could you clarify on RPI increases? Does it apply?
It will, this is again presumably upward and downward rent review, but I think the surrender point, I think I mentioned in the context, if it's a business tenancy and it gets to a surrender and regrant post the legislation coming in, if it comes within the definition in the 54 Act, suddenly it'll start to apply. You'll have an upward and downward review. But what was the next question, Lizzie?
What about the ban on RPI in 2030?
In terms of RPI generally, the legislation will apply to RPI to any situation where the rent is not able to be ascertained at the very beginning. So RPI will be subject to upward and downward review. But as I mentioned earlier, if you take a 5-year time period, I can't think of times when RPI has gone down over a 5-year time period. So RPI or CPI in the future might be the one to go through. And you mentioned the ban in 2030.
Yeah.
It's not going to be banned. It's just that the government's not going to use it as a way of deciding on things like inflation. They're going to use CPIH, which is Consumer Prices Index with housing costs. It's not written in stone yet. They've been saying it for quite a while. A lot of new leases that depend on RPI have been, sort of referring to CPI instead. I think the consensus is that CPI increases will be lower than RPI increases. But they're not suddenly going to be banned. All those existing leases that are based on RPI, unless you go through a variation, will still be based on RPI, but RPI will be based on CPIH. I think the problem for landlords is that it's probably, if you're referring to RPI and the likes, it's going to reduce the rent increases in spite of what we've just been talking about.
And does contracting out of the security of tenure provisions of the 54 Act make any difference to the ban on upwards only reviews?
No, the legislation, if again it comes in its current form, I'm sure this won't change. They've got anti-avoidance provisions. You can't exclude the provisions.
And what happens if there's an option to lease agreement agreed, but the option notice is only served after 2028? Would the lease have to be varied to reflect these changes to the Landlord and Tenant Act?
That's a good one, actually. I mean, I presume an option is an estate contract. It's a contract to create a legal estate in the future. So, per se, it shouldn't apply to the options created prior to the legislation coming in. I think that's probably open to litigation. But that's my gut feeling on it because it's a contract already you've entered into.
Next question is, I think I read somewhere that the ban applies to put options where the rent is unknown. Is that correct? Can you expand upon this?
Yeah, it does. I mean, it's again an anti-avoidance provision. If there's an option to put, as opposed to an option to renew. Options to renew seem to have been forgotten a little bit in the legislation. So going back to the previous question, we'll have to see. But options to put, where the landlord can require the tenant to take on a new lease, as long as the option to put was entered into post the legislation coming in, will apply equally. They'll have upward and downward rent reviews.
Next question. Could you express leases to state that the provisions of this legislation would not apply?
No, if it comes within the definition of the 54 Act, including contracting out, it'll apply.
And we spoke about the AP Wireless case on the course, and we've done a separate podcast on it, but where does this leave periodic tenancies?
Well, I can't help but think AP Wireless and Ontario is wrong. It's this, true attention to the fact we've known for hundreds of years that leases have to have a fixed maximum duration. And they decided that a lease for 10 years and then any time terminated no earlier than 10 years, either side could give a year's notice, 12 months notice, wasn't a fixed maximum duration. If that's correct, and it's a Court of Appeal case, it is a real game changer. There'd been a House of Lords, as they were, case from 1992 called Prudential and the London Residuary Body, which had dealt with these kind of things. And I think the courts have got themselves into a real tangle. But they said periodic tenancies would still have a fixed maximum duration because at any time either side would know what time period you had to give notice to quit, which is usually a full period's notice terminating on a period of tenancy, 6 months terminating on a period if it's a yearly tenancy. But we'll have to see what happens with that.
Okay, one last question. If a landlord is successful in claiming ground G and then subsequently grants a lease to a third party, does the previous tenant have any recourse?
Yeah, that's under the 54 Landlord and Tenant Act, and ground G being where you intend to occupy for your own purposes. There was a case I didn't actually mention that was in the notes, McDonald's and Shiriyama Shokusan, which all took place in the it's the old County Hall in London. And there is provision under Section 37A of the 54 Act that if you don't get a new lease because of the landlord's misrepresentations, then you can be sued and the landlord will have to pay compensation. And that's what the court decided in that particular case. There was, but the landlord, if you like, is not sort of bound to stay there forevermore. And if they decide to change their mind, there'd been a case of years back from 2009 called Patel and Kellers, which was took place in Tudor Street near Chancery Lane in London, where the landlord entered into undertakings they intended to occupy for the next 2 years. And then they seem to have had intentions, they'd run their business, their shop from this premises, but then they might just intend to sort of sell on to somebody else. And the court said, you're not stuck there forevermore. But if at the time you use ground G, you have some kind of clear intention in 2 years or whenever it might be from now, you're going to sell, then you can't. They failed. And that's it for today.
Thank you very much.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.